Brady disclosure from Wikipedia. The free encyclopedia Brady disclosure consists of exculpatory or impeaching information and evidence that is material to the guilt or innocence or to the punishment of a defendant. The term comes from the U.S. Supreme Court case Brady v. Maryland, 1, in which the Supreme Court ruled that suppression by the prosecution of evidence favorable to a defendant who has requested it violates due process. Following Brady, the prosecutor must disclose evidence or information that would prove the innocence of the defendant or would enable the defense to more effectively impeach the credibility of government witnesses. Evidence that would serve to reduce the defendant's sentence must also be disclosed by the prosecution. Definition of the Brady Rule. The Brady Doctrine is a pretrial discovery rule that was established by the United States Supreme Court in Brady v. Maryland in 1963. 2. The rule requires that the prosecution must turn over all exculpatory evidence to the defendant in a criminal case. Exculpatory evidence is evidence that might exonerate the defendant. Examples include the following. The prosecutor must disclose an agreement not to prosecute a witness in exchange for the witness's testimony. 3. The prosecutor must disclose leniency or preferential treatment agreements made with witnesses in exchange for testimony. 4. The prosecutor must disclose exculpatory evidence known only to the police. That is, the prosecutor has a duty to reach out to the police and establish regular procedures by which the police must inform him of anything that tends to prove the innocence of the defendant. 5. Not all exculpatory evidence is required to be disclosed by Brady and its progeny. Only evidence that is material to guilt or punishment, with material evidence being defined as such as to create a reasonable probability that disclosure of the evidence would have changed the outcome of the proceeding. 6. However, the prosecutor is not obligated to personally review police files in search of exculpatory information when the defendant asks for it. 7. The Supreme Court observed in Strickler v. Green. Thus the term Brady violation is sometimes used to refer to any breach of the broad obligation to disclose exculpatory evidence, that is, to any suppression of so-called Brady material, although strictly speaking, there is never a real Brady violation unless the non-disclosure was so serious that there is a reasonable probability that the suppressed evidence would have produced a different verdict. 8. 9. The prosecutor must disclose arrest photographs of the defendant when those photos do not match the victim's description. 10. Some state systems have expansively defined Brady material to include many other items, including for example any documents which might reflect negatively on a witness's credibility. 11. Police officers who have been dishonest are sometimes referred to as Brady cops. Because of the Brady ruling, prosecutors are required to notify defendants and their attorneys whenever a law enforcement official involved in their case has a sustained record for knowingly lying in an official capacity. Procedures for compliance. In order to ensure compliance with Brady, the United States Supreme Court repeatedly urged the careful prosecutor to favor disclosure over concealment. 13. Conformity with Brady is a continuing obligation of prosecutors. Some prosecuting attorney offices have adopted and created specialized procedure and bureaus to meet their burden. 14. PUNTA v. Superior Court 15 is the source for a PUNTA motion. Such a motion can be made by a criminal defendant to discover complaints made against a police officer, and the investigation of those complaints, such that they are contained in the officer's personnel records. The motions can be made in a California Superior Court under California Evidence Code 1043 to 1046. 16. Notwithstanding the broad nature of the discovery that the Associated Court rule and statute provide, getting actual records is problematic. In California, there is a carefully prescribed procedure governing such request, and making disclosure without an order is a crime. The statutory scheme was developed, in part, because law enforcement departments had developed a practice of purging their files concerning misconduct claims made against their officers.
In 1963, the U.S. Supreme Court decided the case of Brady versus Maryland and held that the due process clause of the 14th Amendment, and certainly the due process clause of the 5th Amendment, required that the government not suppress evidence that would exculpate or would tend to exculpate the defendant. The scope, that was much easier to state the principle of Brady than to enforce it. And Brady continues to vex our courts and to vex our prosecutors and to vex, certainly got to be vexing to defendants as well and to their counsel as to what the scope of the right is under Brady and the extent of the problem. We're going to present for you, we have only 45 minutes for this session, and then we're going to break into our constituent sessions. But during this time, we are going to offer you a discussion or debate between some very well-qualified people. We have with us, visiting from Dallas, Texas, Sydney Powell. Sydney is a former assistant United States attorney. She is now in private practice, where she does mostly criminal defense work and mostly appellate work. Sydney has written a provocative book called License to Lie, which is a criticism of the Department of Justice and its practices under Brady. She begins with an extensive discussion of the prosecution of Senator Stevens of Alaska and some of the debacle that followed that prosecution. She also has criticism coming out of the Enron prosecution, in which she had a front row seat. Sydney is critical as well of other parts of the Department of Justice. Opposite Sydney, we welcome Jenny Durkin. Jenny is the inverse of Sydney. She was formerly a defense attorney and in private practice, and is now the United States Attorney in the Western District of Washington in Seattle. I'm sure that they'll provide us with a different perspective on both the scope and the nature of the problem concerning Brady. To moderate this, we've invited Senior Circuit Judge Michael Daley Hawkins. He's uniquely qualified for this. Judge Hawkins is both a former United States attorney and was in private practice in Arizona. And if any of you have appeared before Judge Hawkins in a criminal matter, you know that Judge Hawkins cares deeply about fair play by both sides and the enforcement of the rules of procedure and the constitutional rights of the defendant. So with that brief introduction, I'll turn it over to Judge Hawkins.
Proceed to this entirely non-controversial subject. How about a round of applause for Jay Bybee and his program committee for putting on really an outstanding program. I was reminded of one of my first experiences as a government lawyer, hearing about the different sides here. I'd been a U.S. attorney for about a week, and an assistant ran in the office and said, I'm supposed to argue an appeal before the Ninth Circuit on Monday, and Judge X has scheduled a trial and says I can't get out of it. And I said, no problem, I'll go argue the appeal. In those days, the panel was disclosed on the day of argument. And I got to the Spring Street Courthouse, this was long before Pasadena, and I knew the two circuit judges that were involved. I knew a lot about them. I had appeared in front of them before. But the third judge was a district judge whose name shall remain anonymous. And I'd never heard a word about him. So I quickly ran to a telephone, called my buddy Mike Walsh, who was the U.S. attorney down in San Diego at the time. Lovely man, not with us anymore. He, like me, had done white-collar work before becoming U.S. attorney, and I said, what about Judge X? Can you tell me anything about him? And he said, oh, he's horrible. He's terrible. And then there's this long pause, and he says, wait a minute, we work for the government now. He's wonderful. So with that in mind, we'll begin our discussion of Brady, and we've decided by an earlier flip of the coin that Ms. Powell would go first. She'll have about 10 minutes to explain why she thinks this is a problem and what is or is not being done about it. Sydney?
Thank you. It's an honor to be with you. I really appreciate being included on the program. I want to acknowledge, first of all, that I think the Department of Justice has taken a lot of good steps in the right direction since the Stevens prosecution to improve and reduce the number of Brady violations. My concern is actually with intentional Brady violations in particular, although any Brady violation is certainly a problem. But the Attorney General has announced that he's going to start taking initial conversations with defendants and taping them. They've made changes to the U.S. Attorney's Manual to broaden the scope of discovery. They have instituted training nationally to make sure prosecutors know their Brady obligations. And I think most U.S. attorneys, without a doubt, do a really great job with large caseloads and all kinds of pressures. The problem comes when there is an outlier, as there were in my book, License to Lie, or those that aren't in the book but that make the Washington Post or USA Today series on prosecutorial misconduct.
Let me interrupt you for just 1 second. I'm a appellate court judge. I can't do without a clock. Can you start the clock? It's on 0.
And I demand more time. It's like the soccer rules, you know, they just add 3 minutes here and there.
Does somebody have a button for that?
I can go by my watch if one.
Go ahead.
Okay. All right, while they're working on the clock problems, like a bad police officer or any other person who doesn't do their job right, that makes it harder for those who do. You can't compete against people who are breaking rules. As Brendan Sullivan said in the Stevens case, if we can't trust the government, if they're going to hide things, then there's just nothing you can do about it. And the worst thing about a Brady violation is you don't know what you don't know. The defense attorneys have no way of getting the evidence that the government has unless the government hands it over in many, many cases. And in the cases in the book in particular, the government was very strategic in shutting down access to any of the other witnesses in the case or anyone who had information for the defense. I think the problem and the rubber really meets the road as long as materiality is allowed to be included in a prosecutor's determination of what to produce. Ellen Yaroshevsky did a study actually interviewing prosecutors and found that they were very well versed in what the courts viewed as material, which is supposed to be the review standard, not the initial determination to produce standard. So as long as materiality is conflated with the decision of whether to produce favorable evidence to the defense to begin with, there are going to be intentional or unintentional Brady violations. I don't think it's even fair to ask a prosecutor, or a judge for that matter, to try to decide what is material to the defense. I mean, after all, that's why the Supreme Court said, if there's a question about it, err in favor of disclosure. So it would take a burden off prosecutors to simply require them to disclose all evidence favorable to the defense. And by that I also mean the real evidence, the real documents, the 302s, the grand jury testimony, whatever the notes may show, whatever the real documents are, because as Judge Sullivan noted in the Stevens case, summaries, which first of all take a whole lot more time and trouble to create, are an opportunity for mischief and mistake. In the cases in the book, and in the Stevens case in particular, the prosecutors were producing summaries that were, maybe only a few lines to summarize thousands of pages of testimony or FBI reports. There's no way that's going to be sufficient. And as judges, you don't have time and can't put yourselves in the shoes of the defense either to figure out what the defense needs to prove its case. There are a number of solutions for the problem that I'd like to suggest. We can certainly do better than we have been doing, and I don't see how we can really afford to have any innocent people in prison, and there are there now. Of course, it's even worse in the state courts. There's some that are absolutely notorious for Brady violations, and I know you've seen some in your circuit and you've reversed some of those cases. But I think the higher standard needs to apply to the Department of Justice because it should be a shining example in all respects, and all U.S. attorneys should be able to stand in a court and say, I represent the United States of America with the greatest amount of integrity. With respect to solutions, I've included in your written materials a Brady compliance order that I think if every state and federal judge entered would go a long way toward stopping Brady violations, both setting time limits and requiring the production of all evidence favorable to the defense, not allowing materiality to factor into it. Even naming prosecutors when you have to write a decision has a profound effect. Referring prosecutors to bar associations for grievances is important. Anything you can do to hold the government accountable and engage in that healthy skepticism Judge Sullivan requested and suggested is going to make a difference. Most prosecutors want to do the right thing, but sometimes they have to be pushed a bit to go look in the file, dig deeper, ask their agents, whatever, to just find the material that is out there that should be produced to the defense. There's a Center for Prosecutorial Integrity that has started a database of Brady violations and prosecutorial misconduct. They have found that 43% of the cases that result in wrongful convictions are attributable to Brady violations and that variety of prosecutorial misconduct. The Constitution Project has also been working on this issue. It's a nonpartisan / bipartisan organization that supported the Fairness and Disclosure of Evidence Act that was introduced into was introduced to at least the Senate committee back in 2012 when the Stevens report came out, the special report of the prosecutor in the Ted Stevens case. That legislation was widely supported by the ACLU, the ABA, the National Association of Criminal Defense Lawyers. Virtually every legal organization in the country favored proceeding with that legislation. The only group that I know that opposed it was the ironically named Department of Justice from that perspective. And it just seems to me that the more open and transparent the department can be in providing evidence favorable to the defense, the more the public and the judges and everyone can trust the department and the citizens. And the citizens can have more faith in our justice system. How am I doing on my time?
You're doing great.
Okay.
You want to save some time for rebuttal?
Yes, I do.
Okay. We'll hear from the government at this time, the United States Attorney.
Thank you, Your Honor. I'd like to thank you and Judge Bybee for having this opportunity. I also want to give a special shout out to Judge Richard Jones for his work on this conference and the conference before, and because he comes from the best district in the Ninth Circuit. In many ways, you know, this was framed as a debate. I was happy to follow the panel on implicit bias. And Judge Kaczynski, Chief Judge Kaczynski, are you in the room? There you are. When I walked in, he said something along the lines of, it's good to see the government in stripes. I'm not saying there was any bias there. Look, this isn't really fairly noted, I think, as a debate, and while as my friends know, I can go toe-to-toe to people, I think that there is much that we agree about. Number one, I think I agree with Ms. Powell, and she agrees, there is no debate about what the obligations of prosecutors who work for the Department of Justice is. Nor is there a reasonable debate about what Eric Holder, as Attorney General, expects from every one of the employees of the Department of Justice. The Department of Justice, the word justice, is not just a name. We are the only agency that has a moral value and a national inspiration contained in the name of the agency, and it means something. We have an obligation to do what is right, to do what is fair, and to do what is just in every single case. I think on this we can agree. But after that, I'm afraid we part ways. And we part ways for a very important reason, and that is because facts matter. When looking at the concrete facts, there is no, and excuse me, Chief Justice, there is no epidemic of Brady violations. I think it is a very important thing for us to be discussing what the limits on government are and to always talk about and be cognizant of what the government's obligations are, because it is the limitations on government, truly, that separate our democracy from what could be tyranny. The Department of Justice and federal prosecutors do not shirk from that duty, nor do we shirk from having that kind of debate. But I do think that it does not serve us well by having a very rhetoric-filled polemic debate. Sometimes that happens around this topic, and I'm reminded from the words of Hamlet that says, "A tale full of sound and fury, signifying nothing." So I would like to discuss three things. The first is, as I said, facts matter. And the facts demonstrate, I think, categorically that there is not an epidemic of Brady violations by Department of Justice prosecutors. We are rightfully held to the highest standard. As I said, we know it is our obligation. But the facts show that true misconduct is not only not rampant, it is rare. The second point I'd like to make is, even though it is rare, we know that's not good enough. While we are a human endeavor, we also understand we need to do more. And I was glad to hear Ms. Powell recognize that Attorney General Holder has done much to improve what the Department of Justice stands for and to hold people accountable and to make sure that these standards are in our bones. I want to talk about that a little bit because we all know that a single case of injustice cannot stand. Finally, the last point I'd like to discuss is that I think it is really a grave mistake for our system of justice to politicize or polarize this issue. I think we would best be served by adopting the American Bar Association resolution that calls upon courts, and I would love to see the Ninth Circuit set the standard on this, calls upon courts to reserve the term prosecutorial misconduct for those cases where there actually is real misconduct, intentional misconduct, bad acts. And where there are just errors, the courts would use the term error. I also think, and I'll end my remarks when I get to it, by talking about the special obligation that I think all of us owe to our society, judges, lawyers, and the court, to protect our system of justice. Because I believe that if we let our system of justice become fodder for the political arguments as the two other branches are, that our society is in peril. So first, let me get back to facts matter. I think the facts demonstrate very clearly that there is not a rampant problem with Brady violations of the Department of Justice. And just as a little bit of background, as Judge Hawkins noted, I came to this job never having prosecuted a case before. My very first cases I ever tried were on behalf of criminal defendants. Brendan Sullivan, I worked with him for a number of years because I practiced and was trained as a young lawyer at Williams & Connolly. I know a lot of you are thinking, I know Brendan Sullivan. Brendan Sullivan is a friend of mine, and Jenny, you know Brendan Sullivan. But I will say, anyone who knows me and anyone who has seen me practice knows that I'm not a person who will punches. I will tell you that since becoming United States Attorney, I hold my lawyers to even higher account than before I was United States Attorney. And I will also tell you that I am immensely proud. I am proud of my colleagues. The U.S. attorneys of the Ninth Circuit are remarkable people and remarkable leaders, and you will not find lawyers more committed to the premises of justice anywhere. They are second to none. I'm proud of the lawyers I lead, and I am proud of our department. But mostly, I am proud of the system we all serve, because while it has problems and errors and challenges, it truly is the thing I believe that makes our society different. Some statistics. I'm watching my clock and the judge is getting nervous.
The judge is listening.
We all know that most lawyers, I didn't appreciate this till I became a federal prosecutor, Most lawyers are bound by the bar rules and subject to the discipline of local bar associations, and that is pretty much the bounds of what their responsibilities and obligations in terms of ethics and where they're held accountable. Every federal prosecutor is also responsible to those bar associations, but in addition, the Department of Justice has an Office of Professional Responsibility. Every time there is a cognizable complaint that a Department of Justice prosecutor has violated one of its duties, that goes to OPR. A complaint can be made by the public, by a judge, by lawyers like Ms. Powell. OPR, also what I affectionately like to call, says, trolls the advance sheets and looks for any opinion in which a Department of Justice prosecutor is held by a court to have violated one of their obligations. And if you like government regulation, you would love being a federal prosecutor, because our regulations are not just our rules of ethics. They flow from the Constitution, from the court rules, from Congress enactments like the Jank Acts. They come from the United States Attorney's Manual and from a multitude of policies that are enacted by the Department of Justice. A violation of any one of those obligations can subject a prosecutor to an investigation by the Office of Professional Responsibility. And so since we have those gates wide open, since anyone can make a complaint, and since the office itself looks for every opinion in the advance sheets to see if there's been a problem, are we suffering from a tsunami of misconduct? No, the statistics show just the opposite is true. If you look at what the Department of Justice does in a 10-year period from about 2002 to 2012, and I've looked at the numbers for 2013, they're consistent. The Department of Justice filed over 800,000 cases against 1 million defendants. 800,000 cases, 1 million defendants. In the same period of time, 1/3 of 1% of cases and complaints brought to OPR warranted an investigation. 1/3 of 1%. Less than 0.03% even related to Brady and disclosure obligations. The statistics show that there just is not that tsunami. And of those complaints, the majority were held to be without grounds. Now, I know I was a criminal defense lawyer and I can hear it, that just shows it's a whitewash. They're internal, they're not doing their job. Well, here in the Ninth Circuit, I don't think anyone would accuse any of our judges of being those that would whitewash any injustice. I just don't believe it. And the statistics from our circuit are not dissimilar. I didn't have the ability to go look at that same 10 period of time, but I did look at the past 2 years. Looking at the Ninth Circuit statistics, now again, we all know how those statistics are arguable, but approximately 20,000 criminal cases are filed in the Ninth Circuit a year. So in a 2-year period, approximately 40,000 cases, criminal cases filed in the Ninth Circuit. In 2 years during that period of time, there have been exactly 42 memorandum dispositions or published opinions that directly address claims of prosecutors violating their obligations. I think that's an astonishing number. And of those 42, only 28 dealt with Department of Justice lawyers. The rest related to state claims and habeas, which I am not here to talk about. I know there'll be questions on it. I'm here to talk about the Department of Justice. Of those 28, only 3 were reversed. So in a 2-year period of time, 40,000 cases, 3 cases. 3 cases too many. Please understand the Department of Justice thinks that's 2 cases too many, but we are a human endeavor. So facts matter, there isn't a problem. I think Ms. Powell has addressed, we put in the things, the steps that Attorney General, my second point, has taken to make sure we do better, and we will do better. We have better training, better supervision, better rules, better policies. One of his first acts as sitting Attorney General was to dismiss the conviction of Senator Ted Stevens. Unheard of for a sitting Attorney General to dismiss a case post-conviction. He did it because he thought it was the right thing to do. The last thing I want to talk about is why we as lawyers and judges, I think, have to be careful in this arena and why it should not become politicized. I'd like to read a quote from a recent Ninth Circuit case. I think it was last week or the week before. I don't want to get into the facts of the case, but it related to payment of CJA funds. And there, in discussing it, the court stated, "Lawyers do not have a ready toolkit for their profession. Instead, their professional reputations are the essence of their livelihood. Reputations matter to the court, to clients, to colleagues, and to the public. In a specialized arena such as criminal defense, the professional circle is even more circumscribed. That's true for prosecutors as well. And so I think, yes, scrutinize, yes, bring the things, but ad hominem attacks against individual prosecutors or judges who don't rule your way, I think disserve the courts and disserve us all as a society. And for example, I know everyone varies their discussions with audiences, but even in this arena, Ms. Powell recently, I read and watched some of her previous things. She has linked the misconduct that she alleges to the tragedy in Benghazi, has suggested that Ted Stevens was indicted and convicted to shift the power in the Senate so Obamacare could be passed, even though Obama was not yet president. Those kind of things outside of another context, I think, have a place. But I think what we have to remember is our courts are different and they are special. And I really mean that to my bones. If you sit outside any courthouse in this country, in any corner, any county, any city, any federal courthouse, and you watch who walks in that courtroom, you will see people of every stripe, young, old, white, black, gay, you name it. They walk in as victims, as witnesses, as family members, as criminal defense lawyers, as judges and bailiffs. And the people walking through those doors bring with them the things that are the most important in their life, the most important things. And then they take those problems and they hand them to complete strangers to decide. And they do it for only one reason. They do it because they trust. They trust and they have faith. And I think we must do all we can to keep and maintain that faith. It does not mean we cannot scrutinize, but it should mean we should not politicize, because our courts cannot become as lowly thought of as the other branches of government, because then people will not trust them, and I believe our society will perish. Thank you.
This complete stranger says you're out of time. Well, Sydney, it's all yours.
Okay, I do have a few points for rebuttal. Let's take the last...
The part about justice, right?
Yes, I'm talking about justice, yes. For example, it was actually Brendan Sullivan who said that the result of the Ted Stevens prosecution was a change in the balance of power in the Senate, and that's true. In terms of what OPR does, it's questionable. There's no transparency. There's just absolutely no transparency for OPR's actions at all. For example, in the Ted Stevens case, we do know that Hank Schulke found intentional misconduct throughout his report. He called it systematic and pervasive, I believe. But the Department of Justice, OPR, found it to be unintentional. And the prosecutors were given at most a 14-day suspension. It was tagged on the 2 assistant U.S. attorneys. None of the department lawyers involved were found responsible. And one was given a 14 or 15-day suspension, and another one, I think, a 40-day suspension. I read somewhere that only 1 day of that suspension had ever been served, that it can get watered down as other people review it. So for the wrongful conviction of a United States senator in which evidence was exculpatory and withheld, including very damning evidence about the government's main witness that they knew was out there and specifically did not get or disclose, that's all that happened. We had a horrible case in Texas. This was a state court case, but everyone should know about it, the Michael Morton case, where a man served 25 years in prison for having been accused of murdering his wife and convicted of murdering his wife, while the prosecutor became a state court judge, hiding the bloody bandana that 25 years later exonerated Michael Morton for the murder of his wife. And the state court judge got 10 days in jail for Michael Morton's 25 years in prison. OPR could do a much better job if they would be more transparent in what they are doing in terms of an investigation. In our case, for example, the Merrill Lynch case in the book, we had prosecutors who actually yellow highlighted evidence as favorable to the defense and then specifically excised some of the key phrases from their summary. So we got a 4-line summary that said somebody didn't recall something when that person had actually said, no, that didn't happen. The Fifth Circuit found that they plainly suppressed evidence favorable to the defense. The bar associations did absolutely nothing about it. OPR did absolutely nothing about it, because unless a court finds a Brady violation, OPR just dismisses it. They don't even really investigate it. They might read the court decision, they might read the whatever I filed with them, but they don't take any action against the prosecutors or conduct a full investigation. So that creates a circular problem. That puts the burden back on the courts to actually find a Brady violation, which means you've got to reverse the criminal conviction because you've had to find its material to find a Brady violation, or OPR won't do anything about it and the state bars won't do anything about it. Ellen Yarashevsky's article makes clear that prosecutors have absolutely no concern for sanctions being imposed against them for Brady violations. So first of all, it's next to impossible to find a Brady violation, the existence and occurrence of it to begin with. And secondly, when one is disclosed, there's no sanction on a prosecutor for having done it, which just exacerbates the problem. The Constitution Project and the Center for Prosecutorial Integrity continue to document increasing numbers of Brady violations, many of them intentional.
All right.
Yes.
Well, we're going to have some time for questions, and I will exercise the prerogative of the chair by asking a question of both our presenters. In fact, I'll ask you both the same question. And I'll start with you, Ms. Powell. Do you think there's a difference in the quality of ethical behavior on the part of line assistant U.S. attorneys and lawyers from Main Justice who may come out to the Western District of Washington and try one case, however headline grabbing it might be?
I do. I think generally the line assistant U.S. attorneys that are in your courtrooms every day, you develop a relationship with them, you know you can trust them, and if they step across the line, you know how to remedy that because you have them with you all the time. And they want to have a good reputation. I mean, I would have stuck myself in the eye with a needle before I would have told any judge in the Fifth Circuit or the Western District of Texas that something that wasn't right. That's how important most assistant U.S. attorneys take their responsibilities, which is why I was so upset when I saw what I saw and had to write the book.
Same question.
I think that there's a distinction between ethics and experience. Every lawyer I've dealt with, whether it's from a Main Justice component or a U.S. Attorney's office, is told and understands they have the same obligation. And that's why I think it's really important to distinguish between true misconduct, where someone is trying to cheat, and misconduct because a case is so large and mistakes are made. And my experience is that when you have, and I think most U.S. attorneys are, if there are somebody trying a case in our courtroom, we try to bird dog that. But it's experience. It's experience for young lawyers. So no, I think that there is the expectation for every lawyer at the Department of Justice is the same.
You don't think there's a difference between your assistants in the Western District of Washington who appear day after day in Jack Kuhnauer or Tom Zilli's courtroom as opposed to someone from the Public Integrity Section who may come out to Seattle and try one case?
If they've been in Jack's courtroom and they survived, yes. Look, there's obviously a difference in every courthouse. You understand what every judge expects of you, and you understand how to move the courtroom, what the lower bench expects, and the like. And I think the judges have a different expectation, but if you have a young lawyer that hasn't had as much training, I don't care if they're from a main component or from one of our offices, we have a duty to make sure they know what they're doing. And so I think that while it would be easy for me to say, yep, that's the mothership that's making all the problems, I think the truth is told, the Department of Justice holds every one of its prosecutors to the same standards, and if we're not meeting it, we need to know. That's what the process is set up to be, and I just have to disagree with Ms. Powell that OPR doesn't take cases seriously. They do. I've been on the end of receiving letters about my lawyers when they've trolled the advance sheets. They take it very seriously. And so I think that the problem is one that we have to really focus on again. Let's call misconduct misconduct, but let's not call every error misconduct. Professional attitudes matter.
I agree with not calling just a mere accident or negligence misconduct. I'm fine with that, but there are instances where there are intentional Brady violations, that prosecutors literally deliberately hide something that they don't want to produce. How many people have been fired from the Department of Justice in the last 10 years for intentional Brady violations?
Well, let's just talk about, I think, the case that you mentioned, for example, the highlighting case from the Brown case. There's a difference between criticizing the process and criticizing the results. I think what is clear is you weren't happy with the results, and so you criticized the process to go there. But this conference is called Access to Justice. And your client was very fortunate. They had the best representation that money could buy, I assume, because Merrill Lynch was paying for it, I assume, because I used to do that work at the trial court level. Then you stepped in, and there was 2 Fifth Circuit hearings, there was district court hearings. They looked at this evidence that you say was wrongly withheld, and you choose one sentence that says they purposely withheld it, but another sentence says what your client really wanted to do was cherry pick the evidence. Courts looked at it, they decided that there was not the error you're talking about. Because you don't like that, there's then criticism of the judges themselves and the circuit panels. I think at some level we have to say, a client gets their process, we have to do what's right, but frankly, the attacks against the individual prosecutors in that case, I think are unjustified, and I don't think they advance the discussion.
Want a quick response before we turn to public questions from the audience?
Yes, basically, it's a book I prayed I would never have to write, but I did because what I saw was egregious, and I want people to have the opportunity to look at it themselves. I think it reflects a serious problem in our country when prosecutors can conduct themselves that way and are instead of being sanctioned in any way or instead promoted. It makes it worse for all the good prosecutors. It destroys public confidence in our system of justice. It makes your jobs as judges harder. There's nothing good about it in any way, shape, or form, and everyone's free to form their own opinion once they have all the facts. But when a prosecutor stands in front of a jury and says that person A said Y, while they're hiding that person A said the exact opposite, and do that 16 to 50 times throughout the case, I think most people would say that that was material. And sometimes judges are just determined to affirm a criminal conviction. Sometimes decisions are result-oriented. It doesn't happen a lot, thank goodness, but when it does, it extracts a toll. And I would just like our system of justice to avoid that toll to the greatest extent we possibly can.
Okay. We have a little bit of time for questions from the audience. I see somebody approaching the microphone on to our right. Just tell us who you are and fire away.
Okay, Jeff Cheshire, Federal Defenders of Arizona. So I think I've seen a couple of things in about 10 years plus of being in federal court, and I think I agree that most prosecutors are trying to do the right thing almost all the time. But I think there's systems, structures that kind of lead folks to have problems. I think one of the things we've seen is the category of problems where the agents don't know what their responsibilities are and there's not good control over the agents, especially when you have big influx of new agents like in Border Patrol, and they show up the day of a hearing, oh, did you mean these photos too when you said disclose everything? And then, we get into that problem of, it's government misconduct, and I know it's very sensitive to the U.S. attorneys. We always try to be very sensitive to that.
Is there a question in there?
Yes. The question is, what I've seen is where I'm just trying to describe what I've seen so we can have context. But when you have, what I think as a defense attorney, when you see a report and then you have a hearing and something very different comes out of the hearing, we start to think there's things that we don't see and we get concerned about it. When you get a report that says, we came in, we saw a gun in plain view, we took it, and then we left, and what you actually find is we left, we developed new information, we came back in, dug in a pile of clothes, found a gun, and then came out. I think those are two very different things, and they have legal consequences. And so we worry that there's things we're not seeing, and that our prosecutors tell us, oh, we didn't think that was a big deal. But we think it's a big deal, and I think that's a problem.
Okay.
Question?
So I don't know if the U.S. Attorney would like to respond to that concern.
Yeah, a couple of things on that is, and it's probably not, I'm not quite sure what the question is, but I think it is. Number one, if you're a criminal defense lawyer and you don't worry, get a new line of work. I worried about everything every time. That's part of the job, and I'm not trying to be snide about that. And I also think that the world of digital evidence is changing how we do our job overnight and changing the ability of lawyers on both sides, whether it's criminal cases or civil cases, to gather and collect all the relevant discovery. I mean, it used to be, now you can take pictures with a, camera phone. And, I think I see Judge Rothstein here. We had Andrew Goldsmith, who was appointed as the discovery coordinator for the Department of Justice. One of the steps we took in the wake of Stevens, worked very closely with the Federal Judicial Center to try to come up with some protocols and policies we could follow in order to make sure that we were working together to make sure everyone got the evidence they needed. Judge Peckman, who I think is also here, there she is, our district has, again, to tout the Western District of Washington, electronic evidence has been a bird dog on that for long, because there's no question that it is more difficult in the human endeavor to get that information. But that is different than intentional acts of hiding it, and that's why I think we have to make those distinctions. Do we have to have better ways to gather that? Yes, and how do we keep innovating that? Because it is changing as rapidly as when we, sitting here, there's 5 more ways for people to communicate than there was yesterday.
Okay. Yes, sir.
I'm Mike Filipovich, the federal defender in Jenny Durkin's district, the Western District of Washington. I also represented one of the legislators who was indicted and convicted before Ted Stevens was convicted, handled the post-conviction matter. So I'm very familiar with that litigation. But my question is this, and it's addressed to Jenny, and that is, you made a long speech about justice, Department of Justice, and access to justice, but isn't there also a responsibility of prosecutors and justice to see that the rules are changed in a way where there's more of an even playing field with the defense and the prosecution in the area of discovery, and specifically in the area of what Brady standards should be applied at the trial level? I had 2 cases post-Stevens where we had to litigate with the district court to get a trial level lower materiality standard for Brady, and had prosecutors in the one district, it wasn't the Western District of Washington, fighting us every step of the way. Eventually in Seattle, they sort of went soft on the issue just to get them to agree that we're going to apply a broader standard rather than hold this, hold the analysis to this appellate standard of Brady, which is a very difficult standard to meet and really is an unworkable standard for a trial-level prosecutor.
Over here.
Should I answer?
Do you want to respond to that, either one of you?
Yeah, I'll answer just a little bit. Mike, I think you're absolutely right, but it's a point I want to make is this, there is no question every defendant is entitled to a fair trial, but I have never seen a perfect trial. And I think materiality is a recognition that their mistakes have to matter, because while we want to make sure that every criminal defense lawyer is provided a fair trial, there are also other interests that come to play in a criminal trial. The interests of the public, the victims, the witnesses, the interest that a fair result, a fair and just result happens, which sometimes means holding someone accountable. And so I think that, the Department of Justice made very clear why we thought materiality shouldn't be read into the way you think, and I frankly think that's the right call.
Over here.
Thank you. I have read the book. by Ms. Powell, and I thought it was terrific. I mean, it was extremely informative and interesting, to say the least. And I don't know how widespread the issue is or not, but clearly in the book, there are documented evidence of this issue and problems. And I'm just trying to understand what the Justice Department is doing in light of what was shown, and it's clear on the pages in that book, to learn from that and to make changes.
That's a great question. There's three parts to that. First of all, there's the Stevens part of the book, which the first thing that we did was dismiss that indictment and have an OPR investigation and cooperate extensively with the Schulke investigation. The Brown case, I don't want to get into it, but I just very much disagree with the representations or the characterizations that Ms. Powell has in the book. If you take it at its most literal thing, two of the categories of documents that she objects that were not produced were given to the district court, and the district court determined that they need not be produced. All of the documents were given to the circuit court, who looked at them and said they did not demand reversal. And so unless the circuit court judges on those panels and the district court judge are part of the conspiracy to deprive people of their due process, unless that happens, then I think it is a very different picture than what's presented in the book. And I don't want to hash that out here because I think, you know, it has been done in many courtrooms and many venues. But for those things that are a mistake, we look at it carefully, and we will institute those policies we need to make sure that we make as few mistakes as possible.
Nothing was done by the Department of Justice to correct what you saw in the book.
This is a question.
Dismiss the Stevens, most of the book is about the Stevens case, frankly, and then part of the book is trying to compare the Brown case to the Stevens case, which we can have a personal debate after this, I think is just a misplaced comparison.
A question for Ms. Powell. What empirical evidence do you have that indicates that the specific problems that you point out in your book are widespread or increasing? We heard General Durkin provided some evidence, and do you have counter evidence?
Yes, including in the written materials is a letter from the Constitution Project that documents a number of cases. The Center for Prosecutorial Integrity is found even more. The Barry Scheck's Innocence Project, as you know, which is usually state-related, is freeing people every day because of Brady violations. Most of the prosecutorial misconduct that is either Brady-related or intentional creates a wrongful conviction.
My question is, do you have any empirical evidence that rebuts General Durkin's evidence?
I have not personally...
Other than anecdotal?
No, I have not personally done any sort of statistical analysis.
Okay, thank you.
Yes.
One last question, then we're going to wrap up. Now, I should say, I believe both U.S. Attorney Durkin and Ms. Powell are going to be in the breakout sessions. So if you're thinking of questions or want to explore this issue further, they'll be available at that time. I take it that's right?
Yes.
Okay. Last question.
Willie Fletcher. I don't have statistical evidence, only my experience in the 15 years I've been an appellate judge. With respect to federal prosecutions, my sense is that the line officers, and I'm answering really Judge Hawkins' question, the line officer, U.S. attorneys are by and large very good. Where I distrust it is when we get DOJ people. That's where I have seen the Brady misbehavior. I think the major problem, however, is not with the federal government at all. It's with the state prosecutions. We see Brady violation after Brady violation coming out of the state courts, and EDPA prevents us from getting at a number of very serious problems, and I greatly regret that that's so.
You know, one thing, again, coming out of the Western District of Washington, that is happening, I think, in other areas that I think will help on the state court is more courts are moving to a caseloads requirement, so that public defenders in the state system, which are just suffering under crushing weights of dockets, that we're moving to making sure that they have the ability to defend their clients in a way that is appropriate. And that's something that the Department of Justice has always weighed in on themselves in our courthouse to say absolutely, because if we don't have that fundamental first line for criminal defendants, we will have problems. The Innocence Project shouldn't have to exist. You know, that is the fail-safe that comes decades after people serve time they should not have to serve. And so one of the things I think that on the state level that, we in the federal level don't see is those crushing caseloads and making sure that there's some caseload requirements for public defenders.
Last word?
I think we would all be better served by open file discovery. The more open the government can be about everything, the more everyone can see what's going on and be able to trust the government, the system of justice, the courts, the prosecutors, the whole enchilada. And I appreciate Ms. Durkin's participation in the debate today.
Will you join me in thanking our participants today in the